Hello, everybody. So good to see you guys. Someone heard me. Oh, she's getting the crumbly bits. Hold on, there's a bunch more in here. More crumbly bits. Hold on, we can make a full cookie out of this. Look, there's a big crumbly bit right there. We're gonna give her a whole paw full of crumbly bits. And then, of course, 2 whole cookies. Well, Blue Buffalo Health Bars. This stream is not sponsored by Blue Buffalo. It should be, though. Oh my goodness. Hello, Manuel. Hello, Nana Laura, honey. Hello, C-Rex. Hello, Eileenie Carlin, honey. Oh, here's your other cookie, baby. Hello, Jerry Matthew Boyd. I thought you'd be with your new wife tonight. I mean, since we found her yesterday. Or was it yesterday? I think it was yesterday. I don't know. My days run together. Man, oh man. I think it was yesterday. I just remember we found her. Hello, Rick. Welcome back. Hello, Charlie. Oh, excuse you, Missy. Excuse you, Ava. Hello, Mortimer Duke. Hello, Linda Applegate. Hello, Catherine Gaston. Yay! Good. I'm glad to hear that. My many emails and chats with the YouTube people might be paying off. Might be. Well, thank you. It's not red, though. It's blue. But thank you so much. It's got butterflies and sparkles, and it's got like little flappies that they're very whimsical. I wanted to be whimsical tonight. Hello, Mark Addy, honey. I have no crumbly bits. My bits are fully intact. Hello, Wire Mother. Thank you so much for being here. Hello, Joey Bag of Donuts. Oh my. I get it. Oh, you are so spoiled. So spoiled. Yes. Yes, they are. Yeah. The match made in heaven. I still, oh man, that short that I cut where it starts out, you belong here. Like, oh, it was perfect timing. Hey, she was beautiful when she was younger. I guarantee it. She absolutely was. Unfortunately, probably late diagnosed and untreated for too long mental health conditions put her in a position where she didn't age gracefully. But that's not her fault. But yeah, that's, neither here nor there. Hello, Salty Buddha Love. I'm so happy to see you. Good morning. Good morning. Good morning. I love you. Good morning. Yes, I took my shower and I got my coffee and I was all set up and ready to go, and I sat down and I realized I never hit export. But thank God I have the computer that I have, because it did it lightning quick. It took it 6 minutes to export that. Not even. I don't even think. No, can't be that. Yeah, it must have been that long, because I hit export and then I hit go live. Oh my goodness, you'll have to send me a picture of it. Oh, guys, it was beautiful. It's camel colors and it's huge. I bet that it was so warm as you knitted it, and I've never seen one of those big figure 8 knitters. That was so neat. I really appreciated you showing me that. Yes, you just need to get on the plane. Bandit. Yep. Yeah, she spent the night in the kennel, and I talked to the vet today, and they said that gabapentin is the absolute only medication for cat anxiety. Okay. And they said that she's on her max dose, which I wouldn't want to give her any more than what she's on, because as it is, she gets like noodly. Just she's just a wet noodle after she has it for like several hours, and I don't like this. But and then now she's got her own, like, I've transformed my bathroom into her room. So she's got her litter box, she's got her food, she's got her water, she's got a window, she's got a bed, she's got her own little cubby in the towel cabinet that she can just sit in and relax. She's got her light. She's very well taken care of, and she prefers isolation. When she and Earl have gotten into it in the past, she has disappeared for a week at a time where I have not seen her. She's gone down in the basement, tucked herself in a corner, and not come out for anything. And I mean anything. So, and at my parents' house, even when she was at my parents', like, my brother didn't even believe that my parents had a cat. My brothers always joked and said that a raccoon was sneaking in the house in the middle of the night and crapping in the litter box. So when after my parents passed away and I went in and I caught Bandit, I sent pictures and I sent videos of Bandit, being relocated here. She was okay at first when she first came here. She did very well, but she and Earl started getting into it, and that's kind of when she went downhill with it. And I'm sure the grief and the loss of my parents, she was dealing with that, and then coming to a home with 3 other cats after she'd been an only cat child for so long. She's 8 years old. For 8 years, she didn't know what another cat was. So I'm sure it was a big transition to her. And when she realized that, you know, Earl likes to play aggressively, she didn't take it as playing, and it spiraled her, and she's not been the same since. So, excuse me. So I'm hoping that her having her own room for a duration of time where she can still smell all of the smells of the house. And I do also, I've got the kennel set up right outside of it. So, like, I can take her out of that room and I can put her in the kennel and she's still protected. But when she's in the kennel, she goes right back in the very, very back corner, far away from anything. She won't even come up to the front to feed. So, like, she's riddled with anxiety. But I'm hoping that if I continue the gabapentin and also do the isolation, like she might find some comfort and some safety when she realizes that she is safe, and then I'll start slowly introducing them closer and closer, like, feeding at the kennel, but where she feeds at one side of the wire and Earl feeds at the other side of the wire. And and it's not going to be a permanent thing because my daughter's taking Earl. So as soon as next semester, or next school year fires up, when she transitions her apartment again, um, it's going to be just her and her roommate, and they're taking Earl. So that'll be when I think Bandit comes back to being a little kitten. I think this one is probably the biggest reason for her anxiety, because he wants to play. He wants to play aggressively. He wants to chase her. She's not okay with that. But I got to do something to improve her quality of life. And right now, what that thing is respecting her boundaries, respecting her need for isolation, and treating her like an absolute princess. I mean, I spent an hour in the bathroom just holding her, cuddling with her, letting her know everything was okay. I stand outside the window, outside, when I'm taking Ava potty, and I talk to her through the window. So she's not alone, and she still gets her cuddles. Hi, Earl. You are awful lovey. So, but that's the story with Bandit for now. You are going to step on that keyboard and you're going to eject me. You're going to do a Billy. Oh, what? Okay, I guess it's kitty kisses time. Hi, buddy. What you doing there? I need to see the computer screen. You're a big boy. You are a big boy. He's not fat. He's really not. Like, he's not fat. He's proportionate. But his breed is huge. He's huge. Yeah. Very proportionately huge cat. Here. Oh, you okay there, Bugs? What did you knock down? Oh, my headache medicine. Thank you. There's only 2 left. I need to refill that with you around. Orange cats are crazy. They are a whole different personality, all their own. They are wild and unpredictable. I love orange cats. I would not own one, though. They have way too much energy for me. So, hi, Spider-Man. Oh, yeah. It sucks. Like, I wish there was another medication or something that I could, rely on. But outside of maybe Benadryl, that's the only other thing that I could think of. And that, I don't know if that would be, I wouldn't want to. It would just make her sleepy. I don't want to make her sleepy all the time. And I don't want to drug my cat forever, But, but I can't can't let her live in this constant state of fear. Hey, Ava, please. I need my hands. Earl. Guys, it's going to be a night like this, huh? Honestly, when with Ava over grooming, because she over grooms on her arms, the vet said that it was allergies and told me to do Benadryl for her. So that might be a thing, possibly. I don't know though. No, they are not. Bandit is my angel. That just happens to piss everywhere, and yeah, I love her. I do love her though. Aww. And she does the little prayer hands, or she makes biscuits outside. That's so cute. I think all of them have that tiny little whatever spot right there. Like with Crow, it was only like 4 or 5 little hairs that were white. It didn't exactly count as a spot, but it was, even though it was only like 4 or 5 little hairs, it was noticeable because he was all black completely. Tiny Kitten Esquire, she has like just a couple stray random white hairs, just one at a time. There's no, and it's only a few on her whole body. I love black cats though. They're my favorite. Absolute favorite are black cats. Yes. Mm. There was a Karen that was walking past someone's bathroom one time and actually started screaming at them that they needed to go to a doctor. I saw the short of it. Oh my gosh. I wonder if I can find that. Hold on. Give me 1 second, guys. I can't see the chat at the moment because I'm looking for this. Oh, no, it's not showing up right away. Maybe it's because maybe they didn't call it Karen. I'm just going to say woman. But she absolutely was a Karen. He had one of those little windows that like just flaps open, and he had it open. It was his house. No, I can't find it. Dang it. I will keep looking for it at another time, and I'll show it to you because it's so hilarious. Oh, it's so funny. She's like, you need to go to a doctor. What are you eating? Maybe it's your diet. He's like, woman, will you just let me go to the bathroom? Yeah, he is. He is. But he's always been, he's so ferret-like. Like he's long and lanky. But as he grew, he filled in and he's still long. He's just long and buff and like, oh man, he's not fat. He's got a primordial pooch that, it hangs down. Like he's not fat. Oh my gosh. Oh my gosh. We have on the Discord, we have a Paw Pets section, so you can post pictures of your pets there. Hint, hint, hint. Woo! 19 months. Oh my gosh. Guys, in less than a month, I'll have been a streamer for 3 years. My 3-year anniversary of going live. Oh my gosh. Linda Applegate, thank you so much. Thank you. That's good to know. It's kind of like, I think Tylenol is okay for cats, but not dogs. It can be lethal for dogs. I don't give anything without Google or vet, like for foods, if I'm going to give like one of the animals something that I'm eating, I Google, can cats eat mango? Yes, they can. I had a cat, Snickerdoodle, that her name was Nikki. Um, and she lived to be, it was 21 or 22. And she had like 6 litters of kittens. Yeah. Oh, that is awesome. That's because everybody loves you. Michelle Moreland. Speaking of everybody loves you. Hi, sweetie. The Benadryl, yeah, the pink outer layer. Yeah. Ava is, according to her weight, she's supposed to have like 3 Benadryl pills. I take 2 and I'm knocked out for a day and a half. 2. Ava, like, her body weight is supposed to be 75 milligrams. And I'm like, no, I will not give my dog that much. They are not all on drugs. No, just Bandit. If the name is fitting. No. But she gets away. That's it. Yeah, no, she doesn't get arrested. Bandit gets away. Oh, kitty at the door. Kitty at the door. Then I love Cherie. Mm-hmm. All right, guys. Hi, Lisette. One white toe. Oh, is she a long hair? I've had to shave my mom's long hair cats. Give them the where they just got their poofy round head and then the rest is all shaved. Hello, Sandy Hurt, sweetie. I think I got everybody. I'm Hey, hey. Do you gotta go potty? Okay, guys. I'm gonna have to put the case on, and then I'm gonna have to take her out real quick and then come right back. I'm so sorry. Tonight is fun. It always is fun, but tonight is fun. This one is compliments of OSG. Old Squishy Gardener messaged me, and he's like, "This would be fun for a live. You should do this one." And I had it downloaded, and I was like, "Oh man, it is good, but it's long, so I won't have anything to clip into Replay Crew Minis tomorrow. But this is worth it. This is so worth it." Sorry about the train.
She's gotta go. Okay. Okay, this is case number 25-00009, GC Benet Brown versus Meyer, store number 231. Okay, what's your name?
Benet Brown.
Good afternoon, Your Honor. Kelsey Hall on behalf of the defendants in here.
Okay. Well, now, from what I see, there's a lot going on here today. You have a lot of motions. And then you have a summary disposition motion also pending.
Yes, Your Honor. I don't believe you.
But I don't think it was noticed
I don't.
today.
Correct. We did not receive a hearing date.
Okay. So, ma'am, would you like, now, I mean, if it depends if you people are ready. I mean, I could hear it unless you want more time on the summary, because it was not noticed. So it does not have to be heard today.
But I have 3 other motions that were.
I know. I'm just saying we got a whole we got a whole bunch of things going on here. Did you ask for did you call my clerk to get a date?
I believe we did. I think that we were supposed to get a date, but it wasn't set. It was in the notice of hearing to be provided by the court.
Okay.
And then
Yeah, and we don't just do that. You got to call her.
Correct. Yes.
And you did call?
Yes, I believe we did. I can double check with my assistant, but
Because usually if you call, they'll pull the book right away and just give you a date.
yes, I don't know. All I know is that we hadn't received a date for it. The notice that we got was for a motion to compel for today, which I believe is our motion to compel.
Okay. I see on here, yeah, I just see motion. Then it says motion to compel. All right, so let me see what I've got here so we can see what Miss Brown does have. I think I've got, well, there was a motion in limine that was filed on July 29th. That was also filed on May 19th. There was a motion for ex parte protective order to limit the defendant's discovery that was filed on July 29th. And then there was an objection to an exhibit list filed on 6/2. Then there was a motion seeking relief to rein in defense counsel's overly broad request, but that was withdrawn.
Excuse me, I have all 3 here that I filed. I called and got a hearing date on all 3.
All 3 what?
All 3 motions that are right here. Those others were not motions that I called and got a hearing.
Okay, well, which ones do you think are supposed to go today?
Okay, I have a hearing for a protective order limiting defense's discovery. Okay.
That's one I read.
Okay, and I also have one because compelling them to produce
Compelling them to
produce discovery responses, which.
Oh, okay. Well, you have plaintiff stipulated order compelling discovery responses, which appears to be a motion to compel.
Yes, ma'am.
Okay, so that's 2. What's the third one?
And the third one was, or is, and the motion to compel is got quite a few documents attached to it. And the third one was, the protective order limiting discovery.
I got that.
We already had the deposition. Okay.
Okay, I got that. Then you have this motion to compel.
Motion and limit.
Okay, that's one I read. Okay, and so you had one that was withdrawn. The only other one was a motion to compel signed authorizations.
I didn't withdraw these, ma'am. These
No.
all here.
I didn't say you withdraw those 3. I said you withdraw this motion seeking relief to rein in defense counsel's overly broad request for medical records.
Yeah.
That you withdrew.
Yeah, because that actually wasn't a motion, because at that time I didn't know I had to call, submit a hearing form and get a date.
Okay,
That's before I knew the procedure.
okay.
So
What about this motion to compel sign authorizations? That's not one you,
I believe that's my motion, Your Honor.
okay, that's yours. Okay. Yes, because it's defendants. Okay. I have a list here and I'm just confusing myself. Okay, so I got your 3.
Thank you.
Is yours going today, the sign authorization? Was that notice for today?
That's the notice that we received, yes.
Okay, so that one's going too.
I've got a question about that.
Yes, ma'am.
They want signed authorization, but yet they just filed a motion for summary disposition.
Okay, what's the question?
Well, the point I'm trying to make, I have a motion here limiting what they can request. Okay, when I was at the deposition, they brought me some authorizations, one of which,
So which one do you want to argue now? The motion to limit the discovery? That's the one you're talking about now? Plaintiff's motion for ex parte protective order to limit the defendant's discovery?
yeah, I guess that would be it.
Or is it the motion in limine filed on 7/29? They both filed on 7/29.
Well, the motion on lemonade was, to prevent them from acquiring all these witnesses, okay?
Okay.
To limit the
Well,
amount,
you want to do that one first?
what, the amount of witnesses?
Yeah, which one? We got to do something. So let's just start with
You
something.
start there.
Okay, so that's a motion in limine where plaintiff seeks to exclude the defendant from calling various experts because they did not treat you.
Yes, ma'am.
Okay, and so you've objected to witnesses from Peretta Center for Orthopedic Surgery, Dr. William Kesto, and Beaumont Medical Group, who are providers for plaintiff. So you don't want them called. And then did you file a response to it?
No, Your Honor, we have not.
Okay,
As Your Honor is aware, you file a witness list, right, in accordance with court rules, listing every potential possible witness that you could call. Obviously, that gets whittled down by the time of trial. And, we put on your witness list as who you're able to call. We have experts that are listed on there that would be potential experts that we could call if we choose to retain them. That would be, relevant to the claims that Ms. Brown is making, in addition to any medical providers that would have been listed on the medical records that we did receive. I think that it is obviously better to be overbroad rather than underbroad on a witness list, especially if the case is going to go to trial, to make sure you have all your bases covered. And I believe that that's in accordance with the Michigan court rules.
well, she argues that since these folks, quote unquote, did not treat her, that they're precluded. That's her argument. They should be precluded from testifying. But the way it works, Ms. Brown, is that so you're alleging that you had injuries as a result of some type of improperly stacked display that fell on you at Meyer. And you're alleging that they were significant injuries to like a rotator cuff. Okay. All right. Let me finish. I'm not saying they weren't.
I have an argument here that I would like to,
About what?
about the witnesses.
Okay, well, go ahead.
Okay, I'm gonna just read, okay, because that works better for me, okay? I said, now here comes the plaintiff, Benet Brown and per, and I seek relief from the court. Please exclude any testimony from persons listed below. They are irrelevant and could unfairly prejudice the court against the plaintiff. The plaintiff feels that this is a tactic by the defendant's counsel to waste the court's time and cause plaintiff to incur unnecessary costs. To grandstand, in other words, the plaintiff states, none of these experts are necessary to this case. They have never met the plaintiff, and any so-called evidence or testimony they are likely to give would be speculative, based on conjecture and generalization, influenced by bias, swayed toward the defendant.
Or, now, just the thought, hear me out. Or it could be based on their medical expertise and them doing exactly what they do in their normal everyday practice and reading test results and then providing a diagnosis, looking at x-rays and providing a diagnosis, stuff that they do every day. But go on with your theories.
Plaintiff states, these so-called experts don't know the plaintiff, never examined the plaintiff, or ever treated the plaintiff for any malady or condition. For these reasons, the plaintiff is requesting the honorable court remove them from the witness list and disallow any testimony they are likely to get. And you did have the list of the doctors.
I did. And did you want to respond to that since she read it in?
Yeah, I mean briefly, Your Honor, those, I believe, obviously there are expert witnesses listed on there that, you know, if we choose to retain, would be allowed under the court rules. It says on there that we haven't retained any of them yet. It's my understanding, I'm familiar with the case. We have not retained any of those experts yet. With regard to, you know, any of the other providers, any, medical records, you know, that we have or Ms. Benet would have provided, those doctors would have been listed on those medical records.
Okay, well, some of them are your witnesses, and it looked like you objected to them calling some people who did provide services to you, such as Beaumont Medical Group. Didn't you go there?
No, I did not, I didn't include them. I only included the doctors per se. They had a list of specialists and, all types of people that were gonna pull from, potentially calling at a,
Okay, well, let me tell you what I can't do is I can't just say blanketly that they can't call those witnesses because they didn't evaluate you. Because the way it kind of works in this kind of case, when you have injuries, they can look at medical records. An expert could just simply look at your medical records, which I'm assuming that they have gotten those, look at them and give an opinion that may be different than what's in the medical records, or give an opinion that says, yes, she suffered from this, but it's not from this injury. It's from something else that's maybe pre-existing. I don't know what the records say, but I can't tell them that they cannot retain the expert to look at the records. And if they, and if they come up with something that's relevant to them, they could call them. But without knowing what the expert is going to be looking at and testifying to, I can't just blanketly exclude them saying it's irrelevant simply because they didn't evaluate you personally.
but I did include some experts and doctors who did evaluate.
And they could probably call those if they wanted to, but they have a right to try to rebut anything that you do present from your own doctors who evaluated you.
But just from the fact, Your Honor, that they're filing a summary disposition without any evidence, okay? They're just saying, I don't have enough evidence, which I do. I have documents pertaining.
Well,
to
we're
that.
not getting to the summary, and so I don't know who has what evidence just yet.
Yeah. That's-
Okay.
But, I won't even speak on that yet. Leave that alone, so, okay.
So basically, you know, those providers that they may choose, and like she said, they haven't even decided if they're going to use anybody yet. It could be relevant that even though they may not have treated you for the specific injury, but as I said before, they could be looking at injuries that may be pre-existing that they may contend don't relate to this accident. I don't know. There's no requirement that any expert witness has to treat you in order to give an opinion, because they can base an opinion off of other facts, other records. So just to say, well, we're going to keep them out simply because they have not specifically treated you directly is just not valid. That's not a good basis. As you have the right to call a witness that did treat you to say something, they have a right to call a witness that maybe did not treat you, but could look at the records that of someone who did treat you and give an opinion that may be more beneficial. And when you say, you know, it's going to prejudice the court against you, that's what witnesses do. That's the whole point of a trial. One side's going to bring a witness one way, and the other side's going to bring a witness that may prejudice against what the other side has put forth. That's normal in a trial.
But isn't it about getting to what the truth is?
Yes. And if they call a witness that says something different than what your witnesses or your experts might say, the jury or the trier fact, if it's a non-jury trial, has to make that decision. Who do they believe? What's correct? What really happened here? And they don't have to believe either expert. They can just say they're both full of nonsense and go from there. Or they can believe one partially, and some of what that one says, they don't have to believe all of it. or they can believe some of what the other one says and not all of it. And that way they make their decision, based upon, let's just say, a hodgepodge of beliefs from each expert. Or they could just throw it all out. Everything the one expert says or everything the other expert says. And that's the beauty of how the process works when they're talking as to who they believe. And they do their job. Usually jurors do at least pretty well, because they sit and they talk about why they don't believe this person, or that evidence didn't gel, or he didn't seem proficient on that. So I kind of don't believe that, but they have a right to at least bring that. And, the argument could be made to the jury. Well, he never saw her. That's something that you can argue if you wanted to. But they got to come back for that. Well, we don't have to. You're doing you can give a medical sound opinion without doing that. And the witness might say, sure, I can. So, these are all questions for a trier of fact. So I really cannot grant that motion and deny them the opportunity to call a witness, even though they say they may not.
Right.
Okay, so that motion in limine is going to be denied for those reasons. So your next motion is for a protective order to limit discovery. You had objected to various exhibits, is that correct?
No, it wasn't that per se. Can I read this?
Okay, well, my notes said employment records, tax returns, educational history, medical records.
All that. That doesn't pertain to this incident.
Okay. So I had medical records that don't reference the January 31st, 2022 incident, city Detroit records, workers' comp records, medical records requests, a decade worth of those, and social security records, state of Michigan records, and IRS records or treasury records. And the defendant did not respond. Presumably, I'm assuming that whatever they're trying to do would show some type of possible pre-existing injury or some way trying to mitigate their damages. What do you want to say?
Yes, Your Honor, and I think this goes towards my motion to compel. This motion that she had filed, I believe it was like back in July.
Yeah, it was.
Yeah, so some of that has been resolved, and she has agreed to sign some of them. So the only ones that are outstanding is medical records from University of Michigan Medicine, Dr. Woolston, Michigan Department of Treasury, Walgreens Pharmacy, and Social Security Administration records. So those are the only ones that are outstanding. And that goes to my motion to compel. As Your Honor stated, under the court rules, under MCR 2.314, we are allowed to, these medical records, this information is discoverable when you put a mental or physical condition into question.
Yeah.
Can I just speak when she gets finished, please?
Mm-hmm.
Right.
When she gets finished. So you said medical records from University of Michigan, the Department of Treasury records, Walgreens, and Social Security are still outstanding.
And Dr. Amy Marie Rolston, Rolston.
Okay. All right. And so that goes to your motion that you're seeking, which is to compel authorizations for that information.
Yes.
And she's obviously in this motion requesting that be limited by protective order so you don't get the authorizations.
Yeah.
Okay. And so medical records, Treasury records, Walgreens, Social Security, and Dr. Woolston. Why is it that you feel that they shouldn't get those?
Deposition on the 12th, Ms. Hall brought me an authorization to sign off on for Social Security records from the date of my birth, 1959, until present. That in itself shows that they are predatory. They just want to try to bring any of, at that point, I'm a baby. So what you're trying to find out is about my parents.
No, they're trying to find out how many ailments you've had that you've claimed, throughout your life, and if possibly your rotator cuff was one of them.
Okay. Maybe. Okay. Hold on. Let's stop at that. Why would you need them from way back at her birth?
That's standard. When you fill out the Social Security Administration form, it's standard to do it from the time of birth until, right, the present date. Obviously, I would be surprised if the Social Security Administration
Has anything.
from when she was born, right? But,
Probably don't.
right, but that's standard to put on the form. That's every case that I've ever seen. That's just standard with on the Social Security Administration form.
Okay.
Yeah, I don't feel they need to know anything about, my sources of income.
Well, ma'am, aren't you asking for damages?
Yeah, but I have proof for that.
Okay, so they not entitled to see what income you have and what you might be worth?
But my damages have nothing to do with
Okay.
me being on Social Security. Okay, I could be homeless. I could have been a homeless person that walked into Myers that day. Would that make me any less valuable because those items, I picked up one and they all fell on me?
I'm not so sure they're going to how valuable you are. Tell her what
Well-
why you seek, let's hold on. Why are you seeking the Social Security records?
Sure. So first of all, Miss Brown testified at her deposition that she is currently on Social Security disability, right? So I think that's important for us to see where other forms of income are coming from, what she was actually disabled for.
Yeah.
And how much she is receiving per month. Additionally, I think she's also making a claim for economic damages.
Right?
And if she has income from other sources, this might reduce her need for certain damages, or show, that maybe she was actually working during the time of the accident or had other things going on. We need to be able to actually verify her testimony. And I think that, that obviously would go towards credibility, character evidence, all that type of stuff on the stand if trial were to come.
I was not working.
Okay, ma'am, but here's what you got to understand. A trial is supposed to be fair to both sides. So, and the gathering of discovery is supposed to be fair to both sides. So even though you have documentation that shows maybe that you weren't working and that, you were aggrieved to a certain amount of damages that you're looking for, they do get a right to try to limit your economic recovery. And whether or not you might have been getting disability for something, if they can see that and connect it to the type of injury that you're saying you have now, that would be very relevant to them. And that could be a defense. So they have to be able to look at these things to see. And anytime, it's not surprising anytime somebody has filed a claim for money damages or economic damages, that you open up to scrutiny your income.
Yeah, but I didn't file any, claim to recover lost wages because
Okay.
I wasn't working.
Okay. But how do they know if you're working or not? They don't know. And you're looking for some amount of money. And if you're receiving disability, it could go to offset some of your claim. It may not, but they at least have a right to look into that to determine if they think they have a good defense there. So that's why I know it's hard when you're the plaintiff to understand why the defendant wants to look into, but anytime you bring a lawsuit like that and you're looking for money, they do have a right to try to develop a defense to limit that. So those things that she's asking for are not unreasonable. Now, I know you have signed off on some things and that's kudos to you, but if you're looking for the Social Security, she says she's also looking for the Department of Treasury. That would be income tax type, state income tax documentation.
Yes, Your Honor, and just briefly, Michigan courts have addressed this issue. The Michigan Court of Appeals has held that tax returns are generally discoverable.
Oh, yes, they are. They are. And then what's Walgreens?
Walgreens Pharmacy, it would be for her prescriptions.
Oh, okay. So whatever meds she might have taken as a result of this injury.
No, she's talking about now.
Or otherwise, because I don't know what your injuries might be.
Injuries resolve themselves within a year, Your Honor.
Okay, but that's what you say.
But I'm the person that got hit.
But ma'am, this is a lawsuit.
They're not suing me though.
They're defending against you suing them. That's the thing. They don't have to take anything you say as true. Look at it that way.
Dr. Amy Ralston, I will not give them any authorization to that. That is my current doctor for my current condition, and I will not.
Okay, ma'am. Then I can certainly limit your request for damages if you do not do that.
No, I will not. That is what my condition is now. That was just diagnosed in 24.
I don't know what your condition is, but they have, what I think it's kind of lost on you
In
is,
the deposition, I told them.
okay, but I think it might be lost to you that just because you said it doesn't make it accurate. They have a right to look into it.
I'm gonna get my cancer doctor's information.
Okay.
They're not gonna find out what I've been going through for the last year. I don't need these hawks trying to display all of my personal information. Excuse my raising up my voice
When you
and
say,
making it personal and privileged to
Well-
the general public because it will be known as open to the public.
well,
At that point, it
I'm
will
not
be
so
public.
sure that that's accurate because we can limit it to just them seeing it. And just because it's there doesn't mean that they will use it. But what they do have a right to see is, I don't know.
It has nothing to do with anything that's pertaining to any injury I have had in the past,
Okay.
period.
All right. Well, I don't know if it does or not. And they, well, ma'am, let me tell you this. Last I checked, I have the final say, not
Okay.
you. Okay.
You're
That,
probably right, girl.
okay. But I fully understand your position. And I fully understand why you feel that way. But I'm just trying to say that anytime you're raising an injury, they have a right to look. Now, that doesn't mean they're going to use it. They might look at it and say, you know what? We're looking at this and we don't really think this connects to that.
Don't need it. They just.
Well, why do you think you need it? Let's listen to their position. Why do you think you would need her records regarding anything such as cancer, if that's what she's been treating for, to relate to damages here?
First things first is to mitigate damages, right, Your Honor? So the very first thing is to make sure that the injuries that she's claiming that happened at Meyer are actually related to the incident and they're not related to other injuries she might have sustained or other medical or health conditions that she has.
You mean it's not as simple as, spilling a drink on yourself and getting $1 million? Like, that doesn't happen for everybody? Granted, that was, a valid suit when you actually look into all of the context and details of it, even though it sounds ridiculous. But that's what she's expecting. She's expecting $1 million payout because a display fell on her and she recovered within a year. It's not a permanent injury. That there's no scar. She didn't have to have surgery. If you recover fully, you're looking at a couple grand at most. At most.
Ongoing, additionally pre-existing injuries or health issues, right? So if there's any, I feel for Ms. Brown. I do. I understand.
I understand what she's
that
saying.
Cancer is a very difficult thing to go through. Unfortunately, Ms. Brown has brought this lawsuit forward, and so we have a right to see pre-existing. How long has her cancer dated back? Has that had any effect on how she's healed? Has that had any effect on the injuries that she's claiming she sustained at Meyer? So that's the reason for it.
Yeah, and let me say this to you. The way it works, Ms. Brown, is discovery is very broad in civil cases. And just because it's broad doesn't necessarily mean everything that is obtained is used. And it doesn't mean everything that is obtained is necessarily admissible. That's down the road at trial. But discovery is very broad, especially when you're raising injuries. And you might very well be correct that maybe none of this predates your injuries and this is something subsequent. Maybe it has no effect on the amount of damages you're seeking, but they do have a right to look into that. And so when you do bring a claim, you're opening it up to everything.
Can authorize that because I just got diagnosed in 2024. I will not authorize it.
All right. So what next?
Let's go with their,
I'm just saying medical records from U of M. I don't see why they're not all of this appears to be relevant to me.
U of M is my cancer doctor.
Okay, ma'am, did I just not say that when you sue for damages, you open up all of your medical history?
I'm not gonna give them that information.
Okay, well, if the court orders it, which I probably will, you have a choice whether you're going to comply with the court order or not. Surely it's an order. They can then, if you don't comply, ask for a sanction. Then we'll deal with that if it gets to that point. The sanction could very well limit your ability to recover anything in the case. But that's how it works. It appears they're not asking for anything. Get a chance to look at.
Why should they be able to look at it? They want to know if I'm gonna die soon. That's really what they want to know.
I don't know what they're.
I know what they want to know. They want to know what stage cancer I have. They want to know what's the odds of this lady live to even get a recovery. So if we can just drag this out as long as we
Now,
can.
let me tell you.
We can hear you all down the hall.
I wasn't yelling at the judge. I'm passionate.
I understand,
And
but
I
you're yelling.
apologize.
That's okay, but you're yelling. Just if you could bring it down some. Thank you.
Thank you. So the bottom line is they can't drag the case out. I have scheduling orders. We will go to trial on a specific date. There's no basis for them to quote, drag it out till quote, you die. That's not going to happen. You're here. You seem to be good health. This case is moving right
I just
along.
look good. That's all.
Well, you sure
I
do.
have to give that to my parents.
And
I'm 65 years old.
you look great.
I look good.
You sure?
Yeah, I look good under any circumstances. I have been through a lot. Cause it's my second cancer. But the thing is, I'm a God-fearing woman. I'm not gonna say I'm a Christian because these alt-right people have tarnished the name of Christians. I'm a follower of Jesus Christ.
All right.
Okay, and that's why I look like this.
Well, you do. And we're going to make sure this case gets resolved it'll be before a year. She can't drag the case out any kind of way just to see if you're going to survive or not. And we pray that you do survive and that this is all going to work out.
And I mean, some people think today is supposed to be the day of the dog going up to the sky. They got all these people all over YouTube talking about this is the day. So you don't know what's going to happen today. I recommend everybody, when you leave here, be careful because there's a bunch of fools out here think this is the day for the, what is it? The rapture. So just everybody be careful because you got people out here that really believe that, just like the people that were waiting on that comment, that hellbot.
Oh, yeah.
They're going to catch a ride. They had $5 in their pocket and they all had on their Nikes waiting, So some people just get so engrossed in conspiracies that they don't think for themselves and they just follow the group. So it's just a bad time out here. But if you.
And lady, you are one of them. You completely reside in the fanatical and fantastical.
Okay, Your Honor. I'm sorry I deviated. Before you make your decision on this order, can we hear about them not complying with my request for discovery?
Well, that's a different one.
Well, why should they be able to?
Well, we're gonna hear yours. If you're saying they didn't comply with your discovery, we're gonna get to that. I can only do one at a time. So on this one, I find that, and this is really two of them because they kind of correlate. Your motion for protective order, that's going to be denied, as I do find that the U of M records, the Department of Treasury, Walgreens Social Security, and Dr. Walston, which are the remaining items, are really relevant to possible defense. Discovery, as I said, can be very broad, although it doesn't necessarily mean things are going to be used, and it doesn't necessarily mean that things are admissible. But I think these things are discoverable due to the nature of the type of damages that you've brought forth in your complaint.
My original lawyer was asking for $500,000.
Well, ma'am, if you're asking for $10, they still have a right to look into finances to see if you're eligible for the 10. That's just the way it works. And so conversely, wait a minute. So conversely, the plaintiff's, defendant's, excuse me, motion to compel is granted for those same documents.
Your Honor,
Mhm.
they're asking for a deposition, summary deposition. They already don't, they're already saying they're not gonna use any of it.
No, I don't know what they're saying because I've looked at it fully, but generally it's saying that, hey, there's no questions of fact and you don't really have not presented enough evidence to make a question of fact for trial, or that there's some kind of legal precedent there that controls it, that says they're entitled to judgment as a matter of law.
And if they're already saying I don't have enough evidence, why should they?
Because until the motion is decided, the case is still moving forward. That's how that works. So let's just say we grant their motion down the road, then the case would be gone and nope.
Still have had access to my privileged information.
It may be or maybe not, because quite frankly, depending on when the motion is heard, they may not even get the authorizations in time and have been able to get the document, because documents from these companies take a while to get. The motion might be heard before any of that actually happens, in which case then they don't have those
But what
things.
motion are you speaking?
Her motion for summary disposition.
And I'm
If you're
ready to defend
amenable,
it.
if you're amenable to hearing it.
I'm ready to defend it.
Okay, so
That's why I'm saying that these authorizations are moot because they're going for a summary disposition.
okay, no, I got to resolve. The way it works, I have to resolve things on my docket, every single thing.
Okay.
Because if this motion, you might be right. It might very well be moot if the motion's granted.
Okay.
But if the motion's granted, your case is done, that your case is over, then they don't care about this. They're not gonna say,
I mean, moot on their part, not mine.
okay,
I plan on winning.
okay, but let me say this. If their motion is asking me to dismiss the case and I grant it,
Well, then, yes, I know that it's over there, but
right,
I have a defense for that.
yeah, we'll hear that.
Great.
Sure we will.
Thank you.
Absolutely. But in the meantime, the case is still pending and I have to move forward and resolve these things, or else someone in the civil division downstairs is going to say, well, what happened to this motion? There's no order here. So I have to have an order, resolving each one of the things so that we make sure the case is decided and it's on track. Okay. So we've got denied on this. We've got granted on that. Then we've got your order,
What did you grant?
their motion to compel the authorization, which is the same as you being denied the protective order so that they can't get the authorization. Okay, so then we've got your motion, which appears to be a motion to compel some discovery.
Yeah, they never complied, Your Honor.
Okay, so what did not they comply? Is there a whole list of these we got to go through?
Personal discovery, and they used a lot of semantics, a lot of legal jargon, and a lot of legal acrobatics not to answer my question.
Okay,
A lawyer used legal jargon? Color me shocked.
so let's see.
Raised some of them and resubmitted them and to the court.
You had number 5, you resubmitted where you were seeking the hire and separation date for a Mr. Banish that used to work at Meyer and the performance reviews information for him.
Several.
So it was unclear. Well, I'm going to do one at a time. So
together here.
So it's unclear to me that the defendant objected. And how was his hire and separation date relevant to your claim?
Because I believe he probably got fired because of what happened to me. Because it was he was right there near the equipment that fell on me.
Okay. All right.
So
So you wanted to see,
non-work product, like his, like why he was released, things of that nature.
all right.
So there's multiple there.
So you didn't really respond to that. So, so do you mind his hire and separation date? As she's indicating that it could be some documentation that shows that culpability in there and that he got fired as a result of this because because somehow he might have been responsible for the display being displayed improperly.
So my only objection to that, Your Honor, would be that, employee files contain privileged and confidential proprietary information, right? And
Such as what?
so under Michigan law, employee files cannot be given out to third parties,
Mhm.
okay? So especially disciplinary actions. I think we would be willing to do it with a
She
protective.
says performance review information. She didn't say disciplinary action.
I think we would be willing to do it with a protective order, Your Honor, because it does contain, I think there's a possibility, I haven't seen it, right, but I think there is a possibility that it could contain confidential proprietary information that Meyer had.
Like what?
So
I don't know.
Like his address and his name?
That's not what she's saying.
They've already given me that.
Yeah, I was gonna say you could call him as a witness if you wanted to. So you could have his name and address. So I'm not sure what the proprietary information is.
yeah, my understanding, right, is that the way that Meyer would be handling internal processes and procedures, which could include performance reviews, can certainly be confidential or proprietary to how they run their business. I have no problem producing his last hire date and discharge date, right? I don't know if we are even in possession of a performance review relating to him. So I don't have an issue producing that if it exists. We produced our answers to discovery on June 3rd, 2025. We pay for everything that is within our possession that she asked for.
Well, I don't know what it is that's different. This is a resubmitted inquiry. So to the extent that they say they're willing to give it to you, so then we're gonna order them to produce that.
Yeah, but she just said his hire and fired.
She just also said she would not object to necessarily a performance review.
Yeah.
She's objecting to anything that they believe is proprietary information. And it could get down, I mean, if it's that serious, I would have to take the item, if it's there in camera, and try to look at it and see if there's anything, quote, that's proprietary or violates the law that should be redacted.
And Your Honor, maybe this would be the best way to do it is I have no problem producing those things. If I review it, realize, okay, there's some confidential proprietary information, I can file a motion for a protective order.
Okay, that's fair. Okay.
But Your Honor, I had more than just that one.
Well, ma'am, okay, can we just get to the next one?
I didn't know if you.
I got a list of things I'm showing. So can I go down my list? And if I'm missing something, then we'll let you add it.
Yes, you may.
Okay.
Oh, I love that the judge has to get permission to do her job. What? That's not how that works.
No problem. So we have the plaintiff also claiming that the defendant's answer to interrogatory number 6 was incomplete and that the vendor for the ice blade scraper. Now, defendant did supplement their answers on June the 20th and did provide some photos of the product, including labels, ID tags, and the name. So it was unclear what information you were seeking other than that.
Yeah, that's not a supplement. That's their original.
Right. That's what I'm saying. They gave you photos, labels, ID tags, and the name.
Yeah, but they said that the further information I was inquiring about, they said they didn't have it.
Which is what?
I have it right here. 1 second, Your Honor.
Sure.
Okay. Okay, let me just state, Your Honor, that when they did supply the, documents I requested and the questions, the answers to the interrogatory, they, combined them in a nonsensical way. They
What does that mean?
The defendant, they named the interrogatories document request. They named the document request interrogatories, and some of the pages go from 1, 2, 3, and then they go, and then there's a gap in the numbers. It's like somebody just threw them up in the air and put them together and said, hey, mix it up. We want to confuse her. So, it's not.
Yeah.
If I were to go through it like at a trial, it's not in the order that it should be.
Well, I do have a note that says that we looked at the interrogatories and 5 to 10 seem to be missing.
But if it's just a matter that the pages are shuffled, what prevents you from putting them in order?
But then when we looked further, apparently they were responded to in the answers to request for production of document. So something happened with how they typed it, I guess.
It's not clear to me. So when I'm able to go through these at a trial, I need them to be clear and
That's
run
fair.
concurrently.
That's fair. Perhaps maybe they could retype them in a manner that makes a little more sense. That it's
The information that she requested with regards to the ice scrapers was already produced to her. It was within our response. She just admitted on the record that she had that.
She's not talking about the ice cream.
no, we were talking about that at first because that was the next thing that you were asking for. And I was unclear. What more did you need? Because you were saying that they know who the vendor is. And I'm thinking that they gave you the information as to who the vendor was because they provided labels, ID tags, and the name.
This is so unnecessarily messy, and it's made worse by the fact that this pro se just wants to argue. She doesn't want results. She just wants to argue.
If I may, Your Honor, she also brought an ice scraper with her to her deposition, which I questioned her about. She said it was the exact same make and model. So she's already knows what make and model the ice scraper is.
Right, okay, but we're not talking about the ice scraper right now.
Well, that's interrogatory number 6.
No, but they were saying they could not find out any information about it as far as the manufacturer, this, that, and the other. And what I said in my answer to that, in order for a vendor to even put a product on the shelf of minors, you have to go through specifics in order for them to be able to know the logistical facts about it and the actual manufacturer. So they said they didn't know anything other than that picture, but they did know. They know the whole slew of things about that.
So what is it that in addition that you're looking
Well,
for?
I got that information because it's listed. All I had to do was Google it.
So then there needs to be nothing else added
The scraper.
to interrogatory number 6.
Is that the scraper?
Yes, that's your claim that it was incomplete because they knew but you're okay with that. So there's no action need be done as to interrogatory number 6.
But
All
I
right.
think she understands that we had kind of moved past that.
Okay. Well, I'm just going in order.
No, about the interrogatories and the documents
Yeah, well,
being combined.
I don't know when we were talking about number interrogatories 5 to 10. That's what we were talking about when I went back, because apparently those answers appear to be missing. So could you all redo the answers to interrogatories 5 to 10 and label them answers to interrogatories 5 to 10 rather than they were in the request for production of documents?
We're talking about interrogatories, right, Your Honor?
5 to 10.
Okay. So number 5 is with regard to insurance. We answered that. And
Okay, but where is it?
we answered it.
Is it
We're
listed?
self-insured. We don't have.
What is it listed in an answer to an interrogatory?
Yes, Your Honor.
Because I'm showing that they were in the request for documents.
I'm looking at the
That they were
answers to plaintiff's first set of interrogatories. It was filed and dated June 3rd, 2025.
okay. So let's
Okay,
see.
let's go through the pages.
Because my notes that I have say that you did respond, but they were inside the request for production of documents, that they didn't have their own answer.
So I'm showing that we do have our own answer, right? So number 5, There's nothing that needs to be produced.
Well, you probably didn't file those with the court, or did you?
No, they would have just been
Yes,
produced
Yes, they
to,
were, Your Honor. They put them in the M file. That's where I got them from.
it would have just been served to Miss Brown because obviously we don't want discovery stuff within public
I
record.
saw them there. They were in there actually. I printed from there.
They get served to her through there.
Well, they're there though. They are actually,
Well, I don't know if I got them.
they're in the M file. Because that's where I printed it from, because they were not sending me any copies.
Well, they might have gone to you, but they might not be filed as a court document. I don't know.
I didn't know M file separated them.
I don't know a lot about it myself. We're still learning how it works.
But if she'd like to see them, here they are. They're all convoluted and mixed up. Maybe you don't realize that they are. Maybe you didn't know. Maybe my name is Paul.
Let's see.
If your honor would like me to provide a copy of what I have right now, I can do that.
And she got served that, is what you're saying.
Well, that's what I provided the court. I think that's what, that's how the court knows about.
Yeah, I think that's how we know, because I think you provided something.
Yeah, and I got that. I printed that straight off of, M5.
When did you give that to us?
It should be, oh, you mean, when did I?
Yeah.
Oh, yeah, here. It's, when I filed the actual motion, for them to discovery response. It says 7/29,
Okay, let me see.
2025.
7/29.
Yeah. Yes, Your Honor.
You see. Okay, here, motion, limited protective order, service, correction to submission, document request 3 and 5, proof of service, motion to compel, that's hers. That's in August. Okay, here, it's the stipulated order, which I think is your motion to compel.
But it's included in there.
Yeah, let me look. I gotta pull it up.
Oh, sorry. That's where it put it.
Oh, I think I printed it out. We got it printed out right here.
If you want to see my original interrogatories and my original document request, question, I have them in the order that I gave them to the defendant in. And when they, provided them back to me, they were all mixed up.
Okay,
Did you want to?
you can come up here. I'm gonna show you this. This says defendant's responses to plaintiff's first request for production of document.
Yep.
Okay,
Yes.
then it goes on to talk about interrogatories. See? We object to interrogatory number 2, object to number 3. That's what I'm saying. Your responses are in the request for document.
Okay, I showed
Or
them
maybe they
though,
titled it wrong. I don't know.
I don't have it titled wrong on here from what we submitted. I don't know. I am more than willing to resubmit.
That's what I was
That's
saying.
fine. Yeah, no, that's totally
This is
fine.
confusing.
I would agree with you. But I'm more than willing to resubmit because what I'm showing on my answers is correct, that it was labeled correctly. I have them in front of me here. So I don't know what happened here, but I'm more than willing to resubmit, just to be extra safe.
Well, who submitted those?
Well, I don't
I mean,
know. They had to do it because there's no way. You didn't do it.
No, I'm more than willing to resubmit it. Because I'm looking at them right here and I see
Let me
that,
see what you've got.
well, I have it on my phone. All right.
She will.
So here, take a look at that. I know, I'm sorry, my phone. So those are the interrogatories.
It's like the same questions.
Right.
The only
Okay.
The only difference is, well, I can't say only because I haven't looked at the whole document on her phone, but it seems to be the title and then the introductory paragraph that talks about first request for production of documents.
I don't know, but like from that, it looks correct on my end.
I see,
But
what
I
you're
don't-
saying, what you're saying.
You're right. I don't want there to be any confusion though. So I'm,
That's why there is confusion. So we can fix it. She can resubmit them.
You know what, Your Honor, I really think, and this is just me, I think they intentionally did it that way. Because most of the answers.
We're not doing conspiracy theories here, Ms.
No.
Brown.
No, but this is an insurance company, okay? And they have histories.
Actually,
This is Meyer. What do you mean an insurance company?
Attorney.
Ma'am, she works for a law firm, Plunkett Cooney. They're representing Meyer. Whether she represents insurance companies on other cases is not relevant. She's not representing one here.
Your Honor, I'm sorry, but I just looked at the answers to request for admission, and the way she wrote out her actual questions, it's number one for the answers for the request to produce that she actually submitted. It states that she's titling stuff interrogatories in the actual
Well,
question.
here's my originals right here. Here's my originals right here.
Okay, well, what does it say? What's your original say? Did you call stuff, things in
No,
that?
I didn't. I called them what they were. And these are, oh, I'm so sorry.
We don't want you to trip. That's all. You're moving kind of fast.
These not the original.
Moving with emphasis.
Because I feel good today. These are not the original originals, but this is a copy of the originals in the order that they originally were. Now the original,
Because she has this date, it says interrogatories.
right? They're all.
Yeah, I'm looking at her plaintiff's first request for production of documents, okay? This is dated on May 9th, 2025. The very first question is, please state the name, address, date of birth, driver's license number, state of issuance of any person answering these interrogatories for Meyer. And that's her request to produce.
But it says interrogatories on the top of this.
But the one she submitted to us says.
I don't understand. I can't figure this out.
But
I'm not even going to. Because you might have titled it
I have the
different.
original ones.
When she says the one she got,
I didn't.
but look at her phone. She can't be lying.
I don't want to.
She's reading from her phone.
And I
So,
Here, I'll pull up the, okay,
so you might have titled it wrong.
here. Plaintiff's first request to produce.
Well, that's what you wrote.
No. This is yours. See your initials right there, BB?
Okay, but I need to be able to see the
You can
words.
see it.
It's
There's,
too small, young lady. I'm 65 years old. You have to
Why-
blow it up.
I am. I don't know what to say
It's too
about
small. I
that.
can see.
I can resubmit
No.
that, but I'm gonna resubmit them in the form that she gave it to.
I didn't give them to him in that form.
Well, I don't know. I'm not involved in when people submit requests for production documents or interrogatories.
But they should be in there.
They normally don't send them to the court unless there's a problem. They send them to each
Oh,
other.
right. They put their answers to the court. And I sent mine to them.
I don't have that.
You are severely mistaken, lady. You think that everything you receive also goes to the court. The judge doesn't see this stuff until the trial. Like, that's how they remain unbiased and removed from the situation. And you don't know what you're talking about, you don't know what you're doing, and you're operating just on emotion and wild allegation.
Yeah.
The only thing I have is what you sent me.
Yeah. Well, that's what, I didn't do that. I didn't put that I didn't put that together.
But
That's what they
when
said.
they served you, I didn't get
Right.
it.
But
Normally, people do not serve the court
Right.
with their answers and their
Right,
requests.
I don't think I did. I didn't. I just gave
So
them.
normally it would not be in this file.
Right. I gave them my request for, after they served me with theirs, and I just kind of mimicked back what they did, interrogatories and
You
documents.
know, there's a
requests.
court rule that covers all this. Did you know?
What?
There is.
That covers what?
Request for production of documents and interrogatories. It tells you, you don't have to mimic anything. It tells you exactly how to write it out,
Well,
what
but,
to expect, how long to expect your responses.
yeah, but no, I
Did you
didn't,
know that?
no, but,
Yeah.
well, oh yeah, I knew that basic part.
Okay.
But I didn't put that together that I gave you, that convoluted, it came to me like that. So what she's saying,
that that's the way they received
I
it.
can't
So
see
that's
it.
why they answered it that way. I don't know, but let's just, because we're not going to ever figure out what happened here.
I may have a solution, Judge. I can send her original versions that she sent us and our answers. And then she can take a look at those.
I have it right
She
here.
can email me back and but then you're saying it's too slow for you to see on the phone.
It
right? So
is.
then, once it's sent to you, you can take a look.
But Your Honor,
make sure everything is in order.
I can send you my originals instead of them sending them to you. I have,
She's not sending them to me. She's sending them to you.
but I already have.
I don't need them.
She doesn't want results. She doesn't want this to be fixed. She just wants to be right, and that's it.
We don't, the court will do absolutely nothing with these answers.
The originals, but it was their response. It's all convoluted. Mine were all separate.
Okay, ma'am, let me tell you something, Ms. Brown.
Ma'am.
It's not that I disbelieve either one of you. Obviously, something happened here that I don't know what happened, so I can't validate either side. All I know is something happened where they have a document that they say they received from you that kind of misstates the names. Then they're claiming they sent the document back misstated because it was a response.
So if you look through that document, it's just so many things that are just mixed up. And listen, I gave them one list of it.
The only thing I saw was it was responding to documents and it was actually interrogatories.
And then there's one page that's got half or something and it stops and the numbers change to something else. It's just all mixed up. And then there's another page somewhere else that's duplicated from one other page.
Well-
It's like, wait a minute. So I had to slowly go through that to figure out what it was. And I explained it right here. Would you like me to read it? Because it's a perfect explanation right here. I read it. I wrote it out. Would you like me to read it?
What,
It explains. It
Explains
explains exactly what the convolution is. So you don't have to try to find all the.
okay, go ahead.
Okay, it says, now here comes plaintiff M. Brown by and through self-representation. Now request the states as follows. The defendant's attorney was served on May 15, 2025 by first-class mail the plaintiff's written discovery request relative to the matter below. Plaintiff's first set of interrogatories directed at the defendant. Plaintiff's first set of requests to produce documents directed to the defendant. The defendant chose to give vague, obfuscated answers to most of the plaintiff's questions interrogatory. Defendant also gave minimal documents that the plaintiff requested, and for this reason, the plaintiff has resubmitted 5 more specific and detailed interrogatory and document requests from the plaintiff's original discovery request. After the plaintiff's closer inspection of the defendant's submissions, plaintiff discovered the interrogatory and request for production of documents were mislabeled. Both submissions were merged in a nonsensical way. The defendant's responses to my request for documents are titled interrogatories and have a mix of my interrogatory questions and answers and document requests and responses in the same document. The interrogatories are titled document requests. This appears to have been done to confuse the plaintiff and should be looked at as discovery abuse. Plaintiff is requesting the court compel the defendant to resubmit the document to plaintiff and have them titled and formatted correctly, along with answering the 5 resubmitted discovery inquiries and submit the documents requested in 5 days.
Okay, so the problem here is she's saying that it wasn't entirely their mix-up, that they were responding to what they received the way it was titled. I don't know. But I can, which I thought I was doing, at least try to clear up the additional 5 questions that you claimed that you asked. And that's what we were going through when we found out that this was a big mix up with the titles. So to the extent that counsel saying that she can resubmit this.
That'll be great, because it's all in order. It should have been just 10 questions on one, 7 on the other.
Okay, well, can we do it this way? Can we, whatever it is you believe you submitted to them with the proper title, can you give that to her? And then she can submit it back with the proper title so it's not confusing?
I'll give.
Because right now she's saying what she got was confusing, so that's why they answered it somewhat confusing.
They got a page with 2 different.
I thought pages 5 to 10 were missing from what they submitted.
If you look at it, you can find more problems with it.
So can we just have you resubmit your request with the document whatever it is that you say you sent, she says she didn't have that one. Can you just resubmit it?
I sent those back in May.
Do you have it still?
I mean, I probably have to dig it out. I mean, I submitted this.
Well, if you want answers that look like they're properly titled, can you just resubmit what you sent?
Well, this is it right here. This is the exact question.
Okay, and if that's the way you submitted it,
Exactly the way. It's just that I had done it over and it doesn't have the title and everything on it. These are the exact questions. Exact.
okay, but why don't you send it in the proper form with
This is just for me.
okay. Ma'am, okay, I get it. That's yours. Can you resubmit it in the proper form?
I did, Your Honor. I don't appreciate, and I'm no offense, but lawyers are tactical at this. I did not send a document that was a misconstrued.
Okay,
I
well,
didn't-
I don't know how she has that.
I didn't do it. It was very
Okay,
self-explanatory.
in a minute, am going to want to go home, and I'm sure you will too, and so will counsel. So we got to stop going around and around and just get something done here, which means submit it again so she can respond to it in the way that you want it responded to, where it makes sense, where you could use it at trial if you need to use it. So those, okay, ma'am, you got to send it to her though.
I will.
Huh?
I will.
So we were going through resubmitted number 5. I said they would produce that. That's the separation and hire date and the actual performance review for Mr. Banish. And if she believes that something needs to be protected, she'll file a protective order on that. Okay, that was interrogatory and resubmitted number 5. For resubmitted number 6, no action need be taken because she says she's clear on that as to who the vendor is now. So you don't have to do anything. The next was interrogatory number 7, where it was a video requested of the actual incident. And the request state whose custody the incident report, video, still photos 3 hours before and after 8:30 a.m. on the date in question is.
Where are you reading?
I'm reading from number 7, where you say that they did not give you that,
Are you
or it's incomplete.
the resubmitted question?
I'm reading what I believe. I'm reading
That they gave me the answers to the question.
the ones that I thought were in dispute.
No, these are the ones right here. Can you look and see if you have the?
Ma'am, I'm reading from my notes. So,
Hey, these here. I don't have what you're reading.
okay, so if that's not an issue, that's number 7.
Let's hear what you say.
The video of the incident's not an issue, then fine.
Read what you have, please. I don't have that. You must be reading from.
You claim that the answer to interrogatory number 7, that no video of the incident is available, is incomplete. Because they said no video was available. You said it was incomplete, and that you requested video surveillance and you want video of you entering Meyer.
Yeah,
That's not an issue.
that is an issue.
So why are you telling me when I'm reading this that it's not an issue? You're complicating my job. Trying to go through these and you're telling me no, and it is what you're
It
looking
is.
for. Okay? So, and your request stated that you wanted to know who had custody of the video incident report and still photos for 3 hours before and after 8:30 a.m. And you wanted that.
Yeah, because they were saying there was no video of the area.
So what are you looking for? The entire store video?
Surveillance of me in the store.
So that's not every video in the store. You're looking for a particular camera?
Just surveillance of myself coming in the store, going
Okay.
through the store. moving
Are you
to-
objecting to providing surveillance of her coming in the store?
Possession of it, Your Honor. This incident happened back in 2022. She filed this lawsuit in 2025. I believe Meyer video was only retained like, at most 90 days, at most.
Yeah.
But the gentleman, the manager said he didn't have video, on the date of the, incident.
He
report.
probably does. What do you mean? The date of the incident?
Yeah, he,
When it actually happened?
yeah, he generated.
3 years ago. He said he didn't have it then.
He said of the area. So in other words, he was covering up.
Okay, but ma'am, we can't, I don't know what he was doing. You can ask him that at trial about it. All I can do is deal with your request. And if they no longer have it, if they had it, and these,
Destroyed it or just,
well, ma'am, you have to request and preserve those things
it
because,
was requested by my attorney.
okay, well, I don't know. All I'm saying is most businesses, they don't keep these things forever. In some instances, these recorders just loop over it again.
Yeah, the request was made right away by my attorney.
Well, ma'am, I can't do anything about a video that's 3 years later that's no longer in existence.
They were saying that they don't have a video, but yet still, even if there's a video. and
What
the
would you
story-
like me to
Well, I
do?
understand, but what I'm saying is I believe they intentionally.
Okay. I don't know that, but you can certainly question them about that. What was their motive? Why isn't it there? Didn't you receive a request? You can do all that at trial. I can't order something that doesn't exist. So as far as number 7,
I don't even see where you're getting 7 from. I don't know why I don't see my 7. I see 6. I just don't see 7.
okay. Ma'am, I'm looking right here. Just so you don't know what you're doing. This is attached to your, ma'am, it's attached here, exhibit number 3.
Can I approach?
It's
See it now.
because this looks to appear to be yours.
See it.
So what are you approaching me
See
for? I see it.
Oh, I did.
I don't need to
didn't
see.
it.
Okay.
Okay, I see it.
So no action need to be taken on that issue because it doesn't exist. Then you object to defendant's response to request for production of document number 2, which says that's not possession of documents responsive to the request. And you say you want photographs, films, videos, and an attempt to recreate the incident, giving rise to the action or to demonstrate any scientific principle. They allegedly state in court filings that it would have an accident recreation expert testify. And you seek documents experts relying on. Well, do you have an accident reconstruction person? Because,
We have not retained one, Your Honor, and if we had retained one, we would have provided the expert report to Ms. Brown.
okay, so,
Well, they made a statement as if they were going to
okay,
definitely.
but so then the answer to that is no accident expert is retained and no report exists.
Correct.
So answer that way, because I don't know what you said.
I think the request was confusing, Your Honor, and we were responding that we didn't have anything responsive to the request.
Okay, well, now you can say you don't, just what I said. That you don't have anything because you don't have an accident expert.
But I don't see why the request should have been confusing. I just repeated what they said exactly.
Well, this is the answer. No document because no accident expert. If that changes, they will be required to supplement and put that down. Defendant required to supplement if that changes.
Okay, now the next one.
Okay. Production of document number 5. Any and all things which you will or may offer as evidence at the time of trial. Okay, well, you're in the duty to supplement that. You said you didn't know.
They had me offer and put forth everything I had, every piece of evidence, every bit of information that I had
Okay.
pertaining to pursuing this claim. They have not provided me anything about any exhibits or anything.
Do we have a trial date set yet? Okay. Well, you need to prepare that answer. Because normally it's in our did you get a pretrial order?
Yes, we did, because I copied it.
You usually ask for exhibits there.
We did file an exhibit list, Your Honor.
Okay.
This one, I don't think we really even have any exhibits necessarily to present. So it says it was non-responsive. I mean, I can.
Well, the answer, defendant said that doesn't know, but it will supplement its answer if it has when it determines. And you need to do that probably, I'd say at least 4 weeks prior to trial, so she can have time to look at it.
Yes.
Make a note, supplement 4 weeks prior to trial. Okay, then she added her requests that seeks emails, letters that are relevant to the case, facts, or pertain to the defendant's knowledge of the incident. Well, that's fair.
It's supposed to say non-work product. I had another supplement I did right after when I.
What do you mean non-work product?
Well.
What does
they're
that
trying
mean?
to say work product means,
Attorney-client product?
right.
Well, no. You're not entitled to that
No,
anyway.
but I want.
You're talking about from Meyer, that things that they might have said back and forth just between themselves and not anything they said to their
Right.
lawyers.
Pertaining to, right, you could please.
And emails between HR management and Mr. Banish. And documents presenting at trial, we already have that. We're gonna do that. And communications involving Mr. Tim Dennell, the store manager, regarding the incident. All of that's relevant.
Sure, but if we didn't produce it, we don't have it.
So did you respond that you don't have it?
I think that there has been confusion on what the answers actually were, and that's why I'm willing to resubmit them, because I don't know what you have in front of you.
What I have is this document here that she submitted with all of her renewed
Yeah.
requests. And to me, those are valid.
Which number are we on right now?
Well, it is some new information that she has sought when she was talking about
The resubmissions.
document request number 5.
What's the produce?
Yes. And she wants now the emails and letters relevant to the case that pertain to defendant's knowledge of the incident, emails between HR management and Mr. Banish regarding the incident, documents that you want to present at trial, and communications involving the store manager regarding the incident, as long as it's not work product.
Right. I don't even have those requests. So I don't know,
When
really, I don't even have.
she says she submitted it through M5.
The ones that we responded to are the ones that we received. I don't even see.
Could you send those?
Your Honor, this
Ma'am.
is.
Listen, I just directed her how to answer those. Can you send them to her again?
Your Honor, this was the motion that I filed. It was a hearing form, and I called. You do them again.
If you want the answers, you'll send them over to her. She says she doesn't have them.
But I found them through infile, and they said they submitted them to, the attorney.
What do you want me to do about that, ma'am?
The infile. said-
Nobody is saying that you didn't do it. She says she just doesn't have it.
It's in infile.
Okay, so you want to get answers that she says she doesn't have, and if she goes to M-File and they're not there, she's not going to answer them because she doesn't have them. You could make life simpler by just giving her the 2 or 3 sheets of paper you got there so she can supplement the answers
It was
instead of arguing with me about it, whether it's in M-File or not.
I thought that when I submitted a request for a stipulated order compelling discovery,
I have that.
this is all one thing.
Did you see it?
Those, no.
It's all-
It's attached to her motion, which she calls a stipulated order.
That's fine, Your Honor, but we're not required to respond to that. We're not required to respond to those discovery requests. We responded to the discovery request that she sent us during the discovery period.
All right. And so now she has said you have them. So I'm telling you to respond to those.
And I have no problem with that, Your Honor.
Okay. And it's attached to her stipulated order compelling defendant to produce discovery responses, which should be a motion to compel discovery. And you called it a stipulated order. It's not a stipulated order. And that was filed July 29th.
So you made this big mess. You did this. You filed questions on a document that didn't require a response. And now you want to cry about it.
Makes sense.
Okay, so I'm just gonna recap what we got here. Just, what?
It was a little bit more under that one. I think I wanted something about, Tim,
I said all of that's granted, ma'am.
Thank you so much.
Okay, so this is what I'm gonna ask council. Prepare an order, please, for this. So as far as her motion in limine is concerned, that's denied. The motion for ex parte protective order to limit discovery, that's denied because I am granting your request to compel sign authorizations for these documents here.
Can we limit the date on Social Security?
Medical records, Department of Treasury, Walgreens, Social Security, and Dr. Wolston. That's the ruling of the court. If you don't like it, I'm sorry, ma'am. I'm tired of going through this at this point. We're going through the same thing over and over, and it is 4:40. I have been very patient, and I'm starting to wane, and I don't want to wane. Okay? All right. Now, as far as her request on this stipulated order, which is her motion to compel your discovery request, those are the additional ones that you're going to be responding to that are attached to that July 29th submission. You will respond to, you said the original ones you're gonna redo.
Send them to her again.
She's gonna send those, just so it's clear that we're not talking about documents, we're talking about interrogatories. But these new ones are attached to the July 29th, and they're just a few. So the first one deals with her request number 5 to produce, and we're going to grant that, which is the separation and hire date for Mr. Banish and a performance review information subject to any protective order that you might choose to file a motion on if you look at it and think there's some kind of protected information in that. As to number 6, no action need be taken. That is to the, and you're going to say this in your order. That's to whether or not you have given them the information as to the ice blade scraper vendor. Defendant need not take any action as the plaintiff has that information. As to number 7, defendant need not take any action. That is to the video of the incident, as there is no video available at this point in time related to surveillance and the defendant coming in and out of the store. So you can say that nothing action need to be taken because the video does not exist. As to request for production, number 2, which deals with documents not in possession of the defendant, which she said were not responsive. Your response is going to be that there are no documents because you don't have an accident expert. This is going to be testified, so there's no other photographs, films, videotapes giving rise to any demonstrating any scientific principles, and that there's no expert report or an expert. So therefore, no action need be taken, but it needs to be supplemented if you do intend to hire an expert. As to request for production number 5, you will produce this at least 4 weeks prior to trial, and that has to deal with any evidence that you may offer, documentary evidence that may be offered at trial. And also the other things that she asked, inclusive of that, would be emails and letters relating to the defendant's knowledge of the incident, emails and communications between HR, upper management, and Mr. Banish regarding the incident. Whatever you're going to file as exhibit lists, those documents, and communications involving store director Tim Dennell regarding the incident, as long as it's not work product with counsel. Those are all going to be turned over. So that's granted.
And that's all from the stipulated order.
From that stipulated order these are attached to. Okay, so you can prepare the order for all of those for me and send them in And we're not doing, obviously, the summary disposition today. So call my clerk
Yep.
and get a date for that. And we can have that heard since she has already seen it. There shouldn't be any major delay on it.
I can order your, like, for a trial date today.
Mhm. Where's the clerk? She back there. It's gonna be after whatever summary disposition date you got.
Did bench trial or jury trial?
That's not trial.
Whew.
I know, sorry.
And you're doing a motion for summary?
They did it. They're gonna need a hearing date.
Yeah, if you can give me one now, that'd be great.
Yeah.
Oh,
October 30th and.
149.
I got a couple of 3-4 appointments in October. I don't have my schedule with me. They're medical related. I have.
That's a motion hearing date?
Yeah. I have to check my schedule. I'm sorry. I did. Matter of fact, I could check wrong.
October 30th works for me.
If I can remember my password, I could see right now when the dates are. Never remember my password. Let's check it out. I can't remember my password to my portal at the University of Michigan. They got all my list of all the dates. I know I got a bunch of dates in October that I have to go and do a bunch of stuff. How about, what's the day? Tuesday? How about, can I call you first thing in the morning? And let you know what my schedule looks like. What date is that? October 30th. Okay, hopefully it won't be on that day, but I'll call you first thing. What's a good time? About 9 o'clock. Yeah, and let you know, that if 30th, it's clear, okay?
That'll
And my apologies, because I should have brought that list, but.
Will you issue an order with like the date and time? No.
You gotta wait.
Once she confirms
When
it.
she confirms is what I'm saying.
I can just call your office.
Okay, that would be great.
Yeah.
Thank you for soliciting. That's
Thank you so much, everybody.
Okay, and then we'll go from there for the trial date after the motion hearing, Judge?
Yes.
Are we setting a trial date right now or are we waiting until the?
She's gonna tell us when the motion, because, the motion's not till the end of October. Trial date might not be till December. And we're short December, so it could be early January at that point. We don't know.
Ms. Brown, do you have my email address?
Is it on your card?
Yes.
Well, but could you give me a secondary card?
Sure.
Just in case you can't.
Yeah, that way, if there's any issues with the discovery, you can get to those with me.
Thank you. Thank you. Sorry for raising my voice. I mean,
That's okay. I understand.
I
Totally
understand.
understand.
That is good. Passionate,
They just hear and see you on the camera, so they get a little nervous.
What is it? They get nervous.
Yeah, they don't want you doing nothing to our judge.
I guess I'm immune to it.
Wait.
We're all set on the recording, Judge?
Yeah, you all,
And I will submit, I believe it's 4 separate orders here.
yeah, and I'm typing those in right now as to what, what you're gonna send me.
It'll probably be first thing tomorrow morning since nobody's gonna see it this afternoon or this.
Yeah, that's fine. No, we
Okay.
need to do it today.
Do I need a copy of those?
And the judge took it off, or the court administrator took it off, or somebody ended it. Holy buckets. Yeah, exactly. And she had a lawyer to start with. She had one. So either she couldn't afford to keep paying him, or he felt that there was no valid case. I've never heard that, Charlie. I've never heard that. Oh, by the way, I got presents. I got presents. I got presents. I'm so excited. There's more coffee from Charlie. Coffee made better at home. And let's see. So this is Great Heights Bold and Robust. Chocolate fudge, molasses, and cinnamon. I can't smell this through the bag. The other one, I could smell. It was just, oh, it was so beautiful. And these bags aren't decorated the same. The other one on the bottom, it was so cute. It said, "Oh, honey, you must be tired. Try the other end." I laughed so hard when I saw that. It was sitting on the counter. So this one says, born in the heart of New York City, Joe Coffee believes in the curiosity and conversation. Oh, this is a completely different brand entirely. So this company, oh, this company does multiple different companies. Like it's not one brand of coffee. It's multiple different roasters that you can choose from. I didn't know that. I did not know that. That is awesome. So these are from Joe Coffee from Amsterdam. This one's Amsterdam. This is salty Buddha coffee. Rich and smooth. Dark chocolate, walnut, and caramel. I think I'm going to love this. Ooh, it's got a little pull tab. That is nifty. That you can just, it's like a dog bone, like half of a dog bone. And then you just pull it right across rather than like cutting, ripping, and tearing. Ooh, I like this. I love this. Wow. This is so cool. Thank you so much, Charlie. I love it. I love it. I love it. The origin of this one is Minas Gerais, Brazil. I know I'm pronouncing that wrong. Entirely wrong. Yep, this one is too. The Veloso family is the producer. Oh my gosh, this is amazing. I love it. I love coffee. Oh, thank you so much. Okay, so I wasn't able to try his coffee because I bought the wrong reusable filter pod thingy. And so he's sending me one so that I can drink it. I love it. So I can drink it without having to buy a new coffee pot, which I do need anyways, but I'm going to put it off as long as I can put it off. Very often I say buckets of fuckets. Yeah. That is one of my sayings. Like when I get overwhelmed with something, yeah. Yeah. I scream it. I do. It's mine. Buckets of fuckets. Yep. I did it. Well, couldn't that just be a deranged fan that or one of his groupies? I mean, it doesn't necessarily have to be him. Oh man, I've never heard any of this. So apparently there are missing folks overlapping tour dates of Garth Brooks. I've never heard this. Never, ever, ever have I heard this. That is so cool. Oh, wow. It's like, I, wow. You did. You made me feel very loved and very special. It took like 6 days to drink those 52 pods. 4 to 6, something like that. That's crazy. I've never heard of it. Oh, but I don't. I would think it would be like one of his roadies or something like that. I would never, in a million years, I would never think that Garth Brooks was doing that. I mean, why would he? What would be the motive? What would be the benefit? I don't know. Well, yeah, he planning on making some kind of a theme park thing? And there was a special meaning behind the theme park too, if I recall. It does. It does. Yeah. We all go to the YouTube University. Sorry guys, I still have that cough. I'm gonna have that for a long time. Still dealing with that. I don't know. I don't know. I don't know. I don't know. I'm not saying you're wrong. I'm just saying, I don't know, man. I don't know. The internet says so many things about so many people. Someday it'll say things about me. So people are going to talk. I'm sure that it's true that events overlap with his tour dates, but I don't believe for a second that it's because of him or or because of his influence, but maybe I'm just naive. It's naivety. I'm gonna go to bed. I am. I love you so much. Thank you. Yeah, exactly. Well, that's all we can do. That's all we can do. I can't wait to see what the internet says about me someday. I did, Tiny Kitten Esquire. And then don't forget, Billy O.T. is the original lawyer kitty. So that's 2 of them. There's 2 of them. You guys are amazing. You kept me laughing, and I think laughter is the best medicine. I think that is why I'm healing. Oh, by the way, I have a doctor's appointment tomorrow. So, no replay crew minis are scheduled or edited, and I don't have any to edit. So, tomorrow I have nothing prepared. And then but I've got my post hospitalization doctor's appointment, and then she's going to schedule me to see a pulmonologist because my lungs are crap. That is actually what the respiratory therapist said. He said, "I'm surprised with as crap as your lungs are, you don't have a pulmonologist already." And I said, "What are you talking about, crap my lungs? What?" He says, "Yeah, your lungs are terrible." This is news to me. What? But oh well, whatever. All I can do is pray about it. Take my Moulin, my new natural herbal supplement. They get sticky in the bottle. I don't know. They don't have one of those little dry packs in them either. But yeah, they stick together, so I gotta shake them. Shake, 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 shake. All right, guys. Be safe, be well, sleep sweet, and much love.